Welcome to today's talk on right to work checks. My name is Callum. I'm an employment and immigration solicitor at Field Seymour Parks, and I'm going to be talking about what right to work checks are, why employers need to do them, and the different types of check an employer can carry out. So to start with, what is right to work? Well, right to work is essentially what it says on the tin. It is the right to do work in the UK. There are various ways that an individual can have this right to work, but there are three main ones that you are most likely to come across. The first way is through citizenship. Of course, a British citizen has the right to work, regardless of whether they have been a citizen from birth or acquired the citizenship via naturalisation. But Irish citizens also have the right to work, under the Common Travel Area Arrangement, a long-standing arrangement between the UK, the Crown Dependencies and Ireland, which predates British and Irish membership of the EU. An individual will also have the right to work if they have indefinite leave to remain in the UK, also known as settled status. Indefinite leave to remain is a form of permanent residence, allowing the holder to remain in the UK without any restrictions. It is ordinarily acquired after living and working in the UK for a continuous period of 5 years. An individual can also have the right to work under the terms of their visa, whether that be a work visa, authorising them to work for one or any organisation, a student visa, allowing them to work on a part-time basis, or a family visa. There are also other, less common sources of right to work status, under the EU settlement scheme, the Commonwealth right of abode, refugee status, and others. Employers are required to confirm that all of their prospective employees have the right to work. Employers must not discriminate against employees who they feel do not look British or Irish by only carrying out checks on them. Right to work checks must be carried out on all prospective employees. Employers must carry out these checks before the employee commences work. Where the employee is on a time-limited visa, the employer must also repeat the right to work checks at the end of the visa. There are strict penalties for employers failing to comply with their obligations. If an employer employs an illegal worker and knew or had reasonable cause to believe that this worker did not have the right to work, the employer may receive a prison sentence of up to 5 years and an unlimited fine. If an employer fails to do the correct right to work checks and unknowingly employs an illegal worker, they may be liable for a fine of up to £20,000. It is therefore absolutely essential that employers carry out these checks properly. Since the 1st of October 2022, there have been 3 types of right to work check that employers can carry out. These are the online Home Office checks, manual checks carried out in person, and checks using an identity service provider. If an employer carries out one of these checks in accordance with the guidance and the code of practice, then they will establish a statutory excuse, protecting them from the penalties mentioned earlier. Employers don't need to obtain any documents to carry out the online Home Office checks. All they need the individual to provide is their date of birth and share code. The share code is generated by the individual, who inputs details from their electronic visa or biometric residence permit into a website to generate the code. They can then give this code to the employer, so that the employer can carry out the right to work check online. However, employers cannot require individuals to generate a share code or to use this service. If an individual refuses to do the online checks, then you will need to carry out your right to work checks manually. In addition, a share code can only be generated using details from an electronic visa or biometric residence permit. So, if an individual derives their right to work from some other source, such as their British citizenship, then they will not be able to generate a share code, and you will not be able to carry out an online check. The main alternative to the online checks is manual checks of the documents evidencing right to work status. During the coronavirus pandemic, these checks could be carried out over a video call. However, these adjusted checks were ceased on the 30th of September 2022. Now, all manual checks must be carried out in person, face to face. There is Home Office guidance, called Annex A, setting out the documents required for these checks. This guidance can be accessed online by searching for Right to Work Annex A. Please note that biometric residence permits are not acceptable as right-to-work documents for manual checks. Biometric residence permit holders must generate a share code to prove their right-to-work status online. The employer must check that the documents in question are genuine, and that photographs of the individual on the identifying documents match their appearance in real life. The employer must also confirm that the right-to-work status granted by the documents has not expired, and that any restrictions that apply must not prevent the individual from doing the intended work. If there are any differences in the names used across the documents, then this must be explained, and supporting documentary evidence must also be provided and checked. For example, a marriage certificate to explain a change in surname. Having carried out the checks, the employer must then keep copies of all documents checked. These copies must be retained throughout the individual's employment and for at least 2 years post-termination of their employment. A new option available to employers carrying out right-to-work checks is to engage the services of an identity service provider, or IDSP. IDSPs use identity document validation technology to confirm the validity of the documents evidencing right-to-work status. The Home Office have produced a list of certified IDSPs who have received certification from certifying bodies confirming that these IDSPs carry out checks in accordance with guidance. There is no requirement for employers to use a certified IDSP for their right-to-work checks, but it will provide more assurance that the IDSP is doing things correctly. The IDSP option is still relatively new, and employers are currently weighing up the pros and cons. On the positive side, the Home Office hopes that IDSPs will reduce human error in right-to-work checks, and, for some employers, engaging an IDSP to carry out bulk checks may be more cost-effective than the admin involved in the employer carrying out checks itself. However, IDSPs do charge fees for their services, and these fees are often structured in such a way that it is only worth engaging them if you require a large number of checks to be carried out. Further, employers still need to carry out due diligence to satisfy themselves that the IDSP is carrying out the checks correctly, and must retain copies of the checks. So using an IDSP does not completely eliminate admin costs for employers. The scope of using IDSPs for right-to-work checks is also relatively limited as it stands, as currently IDSPs can only be used for checks on British and Irish passports. So employers cannot use an IDSP if the individual's right to work derives from indefinite leave to remain or a visa. However, there may be circumstances in which the aforementioned options are not available. You may be asking, what if my prospective employee is waiting for a decision on their visa application? Or, what if they are waiting for their biometric residence permit to be delivered? In situations like these, an employer can use the online employer checking service, provided they have the permission of the individual in question to do so. The employer will also need the employee to provide personal details, including their full name, date of birth, nationality, home address, and any Home Office reference number or case ID. These details should be provided on the ECS site along with the employee's job title and hours worked per week. If the individual does have the right to work, the employer will be sent a positive verification notice, which provides the employer with a statutory excuse to employ the individual for 6 months. This should be enough time to cover any wait for a visa decision or biometric residence permit. Please note that where a migrant worker's visa has expired and they are renewing their visa or obtaining a new visa in order to work for the employer must obtain the positive verification notice before the 28th day after the original visa expires. Thanks for watching this talk. I hope you found it interesting and helpful. If you have any questions regarding right to work, please do get in touch.